This one's for all of my estate planning and real estate attorney friends and colleagues in California. If you haven't read the decision that came out from the California Supreme Court at the end of May, Prang versus Los Angeles County Assessment Appeals Board, I highly recommend that you go and read that. It's like 46 pages long. It's kind of long. But it's really interesting because it answers a question that comes up all the time in our group conversations about, is this transfer going to trigger reassessment of the property taxes? Because we already know, because of Prop 8, our property taxes stay generally pretty low from the time that you purchase it, because it can only increase 2% plus your special assessments on an annual basis, if that. So when we're transferring property from how it's currently held into a trust or into a different entity, an LLC, a corporation, even amongst other people, the question that we're always asking is, will this trigger reassessment of the property taxes? And if so, by how much? This one's really interesting too, because with the Prang case, this happened a while ago, right? This case has been working its way through the court systems for almost 10 years. I'm actually just going to read a paragraph from the opinion that goes through the facts, because it's really succinct and it gets right to the point. So in the Prang case, a family corporation transferred ownership of a pair of supermarkets to one of its shareholders, a revocable trust. The trust owned all of the corporation's voting stock, and that's a really important fact. The corporation also held a small number of individual shareholders that held non-voting stock. Those shareholders had no interest in the trust. The transfer of the properties to the trust thus eliminated whatever interest the individual shareholders held in the corporation's real property. The question presented is whether this transfer of the properties nonetheless is excluded from change in ownership under Section 62, Subdivision A2. That is, whether the proportional ownership of interests in the real property transferred, as represented by stock, partnership interest, or otherwise, remained the same before and after the transfer. Actually, I kind of want to go into more of the facts, because it's just, this is such a good case, because we deal with this stuff all the time. And as estate planning attorneys, one of the things that we're talking about is succession planning. And this family, the Amen family, these are the ones that actually owned the grocery store and the real estate. It's the Amen family, A-M-E-N. Jeff Prang was the assessor for LA County at the time of this case. So the Amen family, they transferred their ownership interest from them as individuals, the husband and wife as individuals, who owned almost 93% of the entity, the corporation, and they owned all of the voting stock within that corporation. So Prang's looking at the ownership structure of the corporation and says, well, this transfer eliminates all of the ownership of the Amens, the husband and wife, as individuals. So this does constitute a change in ownership. The effect of that was it took their property assessments from 5.1 million to almost 10.3 million, which is a huge, it doubled their taxable assessed value, which is going to shoot up their property taxes. The appeals board stepped in and says, no, Mr. Assessor, Mr. Prang, no, you're wrong. They didn't have any support for their statement, but what they said was that the beneficial interest in the corporation, in the corporate real property, is ultimately held by the person who controls the corporation through its voting stock, even though there's nothing in Section 62 or 64 that talks about change in ownership in that specific context. So once that happened, the assessor filed a petition for writ of mandate in the Superior Court. Superior Court granted the petition and issued an order directing the Appeals Board, the LA County Assessor's Appeals Board, to vacate its decision and uphold Prang's original assessment that, nope, this is a change of ownership and the property needs to be reassessed. The trustees of the trust, the Amens, then appealed. The California Court of Appeals affirmed the Appeals Board, the LA County Appeals Board. They rejected the appeal board interpretation of Section 62 and agreed with the assessor, Prang. They said, no, this is a change in ownership. You have no basis to say that there was no change in ownership. So where the Supreme Court steps in, the California Supreme Court steps in, they come in and say Section 62 is not ambiguous at all. It says that the proportional ownership interest should be measured by all corporate stock, not just the controlling stock like the trustees were arguing. And back to why when we as estate planning attorneys are working with our clients on succession planning for their businesses, this should be a huge part of the conversation in determining whether or not we should outright transfer ownership of corporate stock to a trust, or if we make additional provisions inside of our estate planning documents because of situations like this. And I think praying is now going to be a guiding light for us when we're talking about our business client owners. Do we transfer your ownership in the stock of the corporation, which we're not actually changing anything on title, right? Like the corporation, let's call it XYZ Corporation, still owns the real estate, but because there's a change inside the structure of the entity, that's why we're getting this issue. That's why the county is now like, oh, let's get our pound of flesh. So you should carefully consider and review with your clients the positives and the negatives of transferring ownership of business ownership, right? Whether it's a corporation that's issuing stock or membership, if there's a membership certificate for an LLC. When you change the proportional ownership of the entity, are you going to inadvertently be triggering a reassessment of property that's owned by that entity? Praying is going to be the answer to that question. And if you're unsure about whether or not a transfer is going to trigger a reassessment, there are two places to go. One is talk to your local county assessor. More often than not, especially in California and especially in Southern California, we have really, really great assessors' offices, and they're there to help and they're there to answer the questions. And it's better to ask them that question than to go do it and try to fix it, because here's one thing. Most of the time, once you've done it, you can't undo it. The second is talk to real estate attorneys that understand the nuances with these section 62 and 64 changes. Like these are not things to mess around with, because if you don't do it right, or if you don't understand the implications of transferring property, you're going to get that call from your client saying, why did I get a notice of reassessment? So check it out. It's Prang versus Los Angeles County Assessment Appeal Board. It's Supreme Court case 266590. You can find it online, but check it, read it out, understand the implications of property ownership transfers, and it's not just transferring the real estate, it is transferring the ownership of the entity. And you're trying to well, how do they find this thing out? They always find out. So you can try and hide it, but you're not going to win.